Yes, Mr. Brady.
Thank you. Afternoon, my lords. Before I embark on the main arguments in response to this appeal, if I may clarify one matter which is put in the written case for the first respondent, and is particularly put in paragraph 28. But I think it's important that I clarify it because it does impinge upon questions of the rule of law and so on, and if I might come on to say something about that. Paragraph 28 is to be found at electronic page 137.
Yes.
And if I could ask your lordships to read the first sentence of that paragraph, the Lord Advocate accepts.
Yeah.
Now, if I may make this clear before I say anything, anything I say should not be taken in any way as suggesting that not complying with a court order is anything other than unacceptable. I think the descriptor that my Lord Reid used was deplorable, and it's for this court to decide on the appropriate descriptor, but certainly from my perspective, your lordships will not hear me seeking to minimise the non-compliance with a court order, and therefore in what I would say, your lordships I think should understand me as describing as a matter of fact what happened rather than exercising any judgment on it one way or another. What is correct to say is that in the period prior to the declarator being granted by Lord Malcolm, the Lord Advocate and the Scottish ministers did make representations to the United Kingdom Government regarding the desirability of commencing the forum bar provisions in Scotland. And I think what would be fair to say is that those representations focused on more than one, as it was seen at the time, potential constitutional issue which had been identified as arising in Scotland as a result of the provisions. Following the grant of the declarator by Lord Malcolm, the Scottish ministers and the Lord Advocate reviewed their position. They recognised that whilst the matter was within the gift of the UK government, the unlawful failure should not continue. But it is also fair to say that in their continued representations to the UK government, their position was that there could be an alternative solution to bring the unlawfulness to an end, other than by immediately commencing the forum bar provisions in the form that they were in. Now, I think from what I've said, it will be apparent to your lordships that that would have had to be a solution which would have required going back to Parliament. But that was nevertheless the Scottish minister's position. The decision about whether the forum bar provisions should be introduced and when was, of course, at all times a matter for the United Kingdom Government. I've acknowledged that representations were made. But as was recognised by both Lord Malcolm in the judicial review proceedings and by the High Court on appeal in these proceedings, neither the Lord Advocate nor the Scottish ministers had the power to decide whether or when the provisions should be commenced. And that was, in a sense, not altered by a view having been expressed by them to the United Kingdom government. So I think the clarification I want to make, and I make this because, of course, I'm responsible for putting in this written case, is that paragraph 28 is perhaps an oversimplification. It is, of course, highly regrettable that a court order was not complied with, although it was a matter within the gift of the UK government. But the first part of that sentence suggests that the Lord Advocate was accepting the fact that there was no other means of doing this other than to commence the provisions in the form that they were in. And that's perhaps an oversimplification because the representations being made, even post-dating the declarator, were that there was an alternative means. It wasn't a binary situation of either bring the provisions into force or don't. There was perhaps an alternative means of doing it, which would solve what was seen as being the constitutional issues, which it gave rise to, but at the same time would involve bringing to an end the unlawful state of affairs which was brought about by the declarator. So I hope that your lordships understand why I want to clarify that, and insofar as paragraph 28 maybe perhaps not present the full picture, well, that's my responsibility, and I apologise to the court.
Can I mention, Mr. Bertie, before you embark on your submissions, one other matter which at some point in the afternoon I think it would be helpful for the court to understand, those who perhaps aren't as familiar as I am with the Scottish background, is what exactly the Lord Advocate's role is in relation to the UK government in relation to extradition proceedings.
Yes, I'd be happy to deal with that in due course. I mean, the simple answer, of course, in Scotland is in terms of Section 191. The Lord Advocate is charged with conducting extradition proceedings in terms of any extradition request which is received by the Scottish Government in Scottish terms. But I can come back to expand upon that, should your Lordship wish me to.
Does he represent the? I'm sorry. Yes. Does he represent the requesting government?
He does indeed. Yes. So in effect, yes. And in the current case, of course, Lord Advocate is here to represent the government of the United States of America. Now, having dealt with the matter which I did, if I might, again, just at the outset, make some observations just about the unlawfulness, and in particular, I think just to address what I have to say about, I think what my Lord Burrows described as the double unlawfulness of that. And I say this just to make absolutely clear my position on it. Up to the point of Lord Malcolm's declarator, the failure to commence the provisions was unlawful. But that was on the basis of the United Kingdom government's erroneous interpretation of Section 61 of the 2003 Act. In other words, the commencement provision, because the UK government's position was that it was perfectly lawful for it to choose to commence in one part of the United Kingdom, but not in another part of the United Kingdom. So that was the unlawfulness. Up until that point in time when Lord Malcolm declared that to be unlawful, I don't think there was any question of incompatibility with the rule of law up until that stage. And his declarator was, of course, granted on the 12th of December 2018. The provisions, of course, as we know, the foreign bar provisions were only enacted in September of this year. And in the intervening period, the extradition hearing took place before the sheriff in June 2019.
You mean the commencement order, number 19, wasn't made until this year?
Quite so, my Lord, yes. September 17th, I think 17th of September of this year. And then in the intervening period, the declarator having been granted on the 12th of December 2018, the extradition hearing before the sheriff took place in June 2019, so some 6 months after that. So, in other words, I accept entirely there was unlawfulness in terms of the failure to commence, certainly up to the point of the declarator. And the question is, well, in what way does that change following upon the grant of the declarator by the court? And of course, I entirely accept that the duty to obey a court order, which has not been set aside, is apt to become a question of the rule of law, of course. It is a fundamental principle of the rule of law that a decision cannot be ignored, and that's entirely accepted. A question, at least in some cases, I suppose a question might arise as to when a failure to obey a court order is apt to be characterised as being incompatible with the rule of law, as opposed to simply being unlawful on the basis upon which the court order was granted. So, for example, it may not be on day one, immediately after the grant of the court order, that it becomes incompatible with the rule of law, because one would expect that the government, the executive, would be entitled to some time in which to act. I recognise that this court may, of course, have a view on when the failure to give Lord Malcolm's declarator effect could be characterised as giving rise to an incompatibility with the rule of law. And in particular, it seems to me that the question is...
It may not be so much a question of, for present purposes, what may be important is not so much how long it took for the commencement order to be made, but more a question of whether it was lawful for the Lord Advocate to begin the proceedings before the sheriff before that step had been taken.
I see that point, my Lord. And I suppose the point I make is that, of course, I understand the importance of the question of rule of law which arises here, and I understand why Mr O'Neill makes that point. In a sense, in terms of framing it in terms of the way in which my Lord Reid has, I'm not sure that it matters whether we're dealing with the prior unlawfulness or whether one's dealing with the incompatibility with the rule of law, because in a sense, what is accepted, if I could put it this way, what is accepted is that the extradition proceeded on the basis of a statutory regime which did not include the foreign bar provisions, and in circumstances where the failure of the UK government to commence those provisions in Scotland had been found to be unlawful. And that was 6 months predating the start of it. But in fact, the unlawfulness dated right back to 2013, when it was commenced in England and Wales, but not in Scotland. So in a sense, the simple point I make is just one to say that whether it proceeds, the fact that the appellant's argument proceeds on the basis of the unlawfulness, which arose prior to the declarator, or whether one premises it on the basis of the incompatibility with the rule of law, really makes no difference, it seems to me, to the case which I require to meet. There is unlawfulness, in other words, and I accept that, and therefore it doesn't matter really how one characterises that. What's at issue is the absence of the forum bar provisions in terms of the statutory regime which was in place when the extradition hearing commenced. Another matter which was raised this morning, again by my Lord Reid, was the question of how many cases might be affected by your Lordship's decision in this. And I think that the answer may depend upon how. If your Lordships are against me, of course, I'm rather hoping not, but if your Lordships are against me, it might depend upon how your Lordships determine this case. Yes. And if I was to put it this way, Mr O'Neill's position proceeds on the basis of the Lord Advocate's decision to conduct the proceedings being a matter of virus. Yep. And for what it's worth, on the premise upon which his appeal proceeds, I don't take issue with that. It would be a question of virus. There's no question of that. And therefore, the argument is that if the argument is otherwise good for the appellant, the Lord Advocate was acting ultra vires by commencing the proceedings at all. Now, one then considers the provision which my Lord Reid identified, and which I think is at page 1753 to 1754 of the electronic file.
Yes.
Which is the transitional provision,
yeah,
which is paragraph 7 of Schedule 20 to the 2013 Act.
Yeah.
And your Lordship read this out this morning, but as the court will be reminded, what it says is that in a case, and what would be appropriate here is in a case where the request for the person's extradition has been issued before the time when the amendments made come into force, those amendments apply to the extradition concerned only if at that time the judge has not yet decided all of the existing extradition bar questions. Yep. So, as I understand it, there is a category of requested person in respect of whom the sheriff will have decided, prior to the commencement, will have decided all of these existing extradition bar questions, and who will not have had the benefit of these provisions, but they have not yet been extradited. In other words, I understand it, I think there are 5 currently on appeal to the High Court, and there are, as I understand it, another 7 who simply have not yet been extradited because the arrangements have not been followed through. Now, so in other words, 12 in total, as I understand it.
When we say the 5 cases on appeal to the High Court, obviously the sheriff has taken the decision and that's under appeal. The other 7, what stage are they actually?
As I understand it, my Lord, they are simply that there is no appeal. A decision has been taken by the ministers following upon the decision by the sheriff. It's gone to the ministers, and either, or so I should put it this way, either a decision is pending or a decision has been taken and they haven't in fact been extradited yet.
Yes.
Now, if one were to take to the extreme the argument advanced for the appellant here, then it seems to me that one might say that the Lord Advocate's decision to proceed against those requested persons in the absence of the forum bar provisions was ultra vires, and therefore it is possible in principle that through one means or another those other requested persons might seek to take advantage of any decision in favour of the appellant here. Yeah. Now, I suppose a question, and the reason why I said at the outset of starting this submission is that it may depend upon how your Lordships, if they were to be against me, were to decide this appeal, is that, yes, of course, in the written case, and I don't think Mr O'Neill addressed it this morning, but in his written case, he appears to accept, and I think it's paragraph 6.2 of his written case, but he appears to accept that the appellant would at least have to get through what he describes as the gateway threshold to the provisions.
Yes.
And I'll come back to address this in the course of my more substantive response, but the gateway provisions is the part of the test under the forum bar provisions in terms of which a requested person would have to show that a substantial measure of the relevant activity occurred in the United Kingdom.
Yes.
Now, if that were right, now, as I'll come on to say in my submission, there's an inherent tension between, on the one hand, Mr O'Neill arguing that if it's not in accordance with law, the whole thing is ultra vires, and yet, on the other hand, accepting that he has to get through the gateway threshold. But if that were right, that one has to get through the gateway threshold, then the number of the 12 people that I'm talking about might come down considerably. Whereas if that's not a requirement of it, then it may be that the outcome of today's appeal might apply to all 12.
Yes.
So,
I imagine you'll deal with this at some point, but at the moment, I'd be inclined to think that if the commencement of the proceedings before the sheriff was ultra vires, then it would follow that those proceedings were a nullity. And the position now in law is the same as if those proceedings had never taken place, in which case, subject to possible defences of oppression, it's open to the Lord Advocate to begin the proceedings before the sheriff all over again, and they would now have to be done in accordance with the Section 83A.
I'd like to reflect on that, if I may, my Lord, but it respectfully seems to me that that is probably right. Subject, of course, to, as Mr O'Neill has made plain, those would be, for example, in relation to, if I were right about those 12 people all having the benefit of this appeal, if that went back to stage 1, then no doubt 12 arguments of oppression would be faced in respect to the fact that they have already faced extradition proceedings and ought not to go through the whole process again.
Yeah.
Can I assist with anything further in that regard?
Well, I'm just thinking aloud on the sort of this point about everybody else being affected. The appellant's in a particularly strong position because the court's order was obviously binding on the parties to the proceedings. So it was binding on the appellant, the Lord Advocate, and the Advocate General. It wouldn't be binding in that sense on strangers to the proceedings, but it would have so its effect vis-à-vis them would be as a precedent.
Yes.
Really. So they would have to argue that in the light of that precedent, it was unlawful for the Lord Advocate to have proceeded against them, whereas the argument for the appellant is slightly different, that the Lord Advocate was bound by the decision. And I don't know if I came across at lunchtime authority to the effect that there is a constitutional convention that the executive will comply with a declaration made by the court, and so the appellant has a sort of, as it were, a gold-plated case, which other people facing extradition would not have. They would have to rely simply on the precedential effect of the declaration of a declarator in establishing what the legal position was.
I don't disagree with that, my Lord. Yes. If I may turn then to deal with the primary issue which seems to me arises on this appeal, which is the question of in accordance with the law.
Yep.
In other words, whether it was in accordance with the law for the Lord Advocate to conduct the extradition proceedings against the appellant on the basis of a statutory regime which contained no forum bar provisions. And I've said this already, I think, but for the avoidance of doubt, if I may repeat it, what is accepted by the Lord Advocate is that the extradition proceedings against the appellant proceeded on the basis of a statutory regime which did not include the forum bar provisions in circumstances where the failure of the UK government to commence those provisions in Scotland had been found to be unlawful. So I accept that as a starting position. But I'd also make this initial observation. The interference with the appellant's private and family life, which requires to be justified, is, of course, the interference comprised in his intended extradition. And the flip side of that is the interference to be justified is not the failure to commence the forum bar provisions per se. There is, of course, no Article 8 right to entitles the appellant to be able to rely on forum bar. And as it is the extradition which requires to be justified in terms of an interference, then it is the conduct of the extradition which is to be justified. And in my submission then, it's appropriate to look at the whole of the extradition proceedings. The fact that the foreign bar provisions had not been commenced where that was found to be unlawful is, of course, a factor which is relevant to the assessment of the Article 8 rights and the interference. But equally, so is the manner in which the courts below were able to consider the effect of the absence of the foreign bar provisions. And I'll come to expand upon that, but that is the key to my submission, in a sense. In legality terms, and of course as I go through, seek to be very careful to distinguish between legality on the one hand and proportionality on the other hand. But when one looks at a mechanism, there was a mechanism available in terms of the 2003 Act, as applied by the courts below, which permitted a consideration of what the effect of the absence of the foreign bar provisions are. And when one...
I was trying to understand how this argument proceeds. When the Lord Advocate commenced the proceedings before the Sheriff, that was either intra vires or ultra vires. If it was ultra vires, that couldn't be cured by what subsequently happened before the Sheriff.
And the point I make, my Lord, is it's not a question of curing by the Sheriff. The point I make, and as I'll come to expand upon, albeit relatively briefly, is that the mechanism existed from the outset of the proceedings. Section 87 exists. It requires the court to consider the convention compatibility of the extradition and the means by which the court approached it in this case in order to consider the prejudice to the appellant, depending upon on the hypothetical that the foreign bar provisions would have been in place, was a mechanism which was plainly open to it. And therefore, it's not a question of coming in at the stage of the Sheriff's the hearing. It was a mechanism that was always open to the Sheriff under the terms of the Extradition Act. So it was a pre-existing mechanism, in other words.
You don't get to the Sheriff's hearing unless the Lord Advocate has commenced the proceedings properly.
That's indeed correct, my Lord. And my point is the Lord Advocate commenced the proceedings properly because the Extradition Act contained within it the mechanism to allow this matter to be dealt with in due course before the Sheriff.
Does that submission lead you to effectively say that it makes no difference whether the foreign bar provisions were brought into force or not? Because if it's a pre-existing mechanism that achieved everything that could be achieved by the statute, there would appear to be no point introducing the statutory bar, the statutory foreign bar.
Well, the mechanism is Section 87. That's the trigger to the mechanism, which is, of course, considering the convention compatibility. In circumstances where the complaint is that foreign bar provisions have not been brought into force, then it can't be a cure-all in the sense of, or in terms of a mechanism. What the mechanism involved in this case was considering the hypothetical of the foreign bar, in other words, looking at the foreign bar provisions and saying, could this appellant have had the benefit of them? And that then, once that mechanism is put into place, in my submission, that then turns into a question of proportionality, because one then looks to the outcome. And if it is true that the appellant could have availed himself of the benefit of the foreign bar provisions, then respectfully seems to me that would be determinative of the proportionality, because if he has been denied a bar which he would have been able to avail himself of, then intrinsically that must be determinative of proportionality. The flip side of it would be if he were not able to avail himself of it, then it may be that he has other arguments available in terms of Article 8. As it happens, I think in this case there was really nothing else. But he may have other Article 8, but it would simply be something that didn't feature in the Article 8 balance.
It wasn't ultra vires of the Lord Advocate to proceed in disregard of the declarator, because the declarator was essentially fatuous, as the commencement of the provisions made no difference to the substantive law.
Yes, and then when it comes to the proportionality, it made no difference to this particular appellant. And if I might, I think I've probably gone further than I intended there, but if I might just to expand on that, and firstly, before I do, if I might just make some observations about the legality test. the question of what's comprised within the in accordance with the law test has of course been the subject of consideration on recent occasions by this court, and before that of course by Strasbourg, and in this court in particular it's been the subject of discussion in cases in particular in re Gallagher, which is tab 55, the case of T and the Chief Constable of Greater Manchester Police, tab 20, and also the case of AB and against Her Majesty's Advocate, which is at tab 22. And in all of those cases, the court, of course, considered all of the principal authorities coming from Strasbourg. I don't intend to ask your lordships to turn up those authorities, and instead, if I might just make clear what I accept as arising from those authorities. The first is that I accept, of course, that the question of whether the test of in accordance with the law is met is a binary question. As Lord Sumption put it in the Gallagher case, in the context of discussing provisions of the Rehabilitation of Offenders Act, either the provisions in question have the quality of law or they do not have the quality of law. And here it seems to me what we're talking about, of course we're not talking about provisions, they're under examination, rather we're talking about the extradition proceedings having been carried out, and whether, as they were carried out, whether they had the quality of law or they did not. But it's a binary question. And second, connected to that, there is, of course, as I entirely accept, no room for the application of any margin of appreciation, unlike in relation to proportionality. So the accordance of the law test is concerned with the quality of the domestic measure, as opposed to proportionality being concerned with the application in particular cases. And that's why, when I accept that, my submission has to be that there was a mechanism within the proceedings by which the absence of the foreign bar provisions could be considered. So it's the mechanism which I'm looking to in terms of dealing with in accordance with the law, rather than looking to the outcome in this particular case. And lastly, in relation to the in accordance with the law test, and this really picks up on a point that my Lord Reid made, I accept that, of course, for it to be in accordance with the law, there must be a basis in domestic law, and one must also meet the dual test of accessibility and foreseeability. And as part of that test of accessibility and foreseeability, there must be adequate safeguards against arbitrary interference. And of course, I accept all of that. And coming back then to the main submission I have to make, which is that in my submission one has regard to the whole of the extradition proceedings to which the appellant was subject. There was a mechanism by which the courts below were able to take account of the absence of the foreign bar provisions. And I simply start by, in reiterating that, I start by saying, well, of course, the 2003 Act remained in force and applicable to the appellant, albeit absent the foreign bar provisions. So there was a basis in domestic law for the appellant's extradition. The courts below were, of course, also required to decide whether his extradition would be compatible with his convention rights in terms of Section 87. No doubt they would have been required to do that in any event, but Section 87 makes that requirement express. And once the courts below were required to consider whether this particular appellant's Article 8 rights would be breached, in my submission, that required them not to consider Article 8 in the abstract, but to consider what the effect of the failure to commence the foreign bar provisions was on this particular appellant. And that, in turn, required the courts below to consider whether the appellant would have been able to avail himself of the foreign bar provisions had they been in force. In a sense, what the court was doing was taking Section 87 and they were applying it to the particular circumstances of this appellant's case. Could he have availed himself of the protection? And whether he could or could not have availed himself of that protection would, in my submission, have been a critical matter in the assessment of the proportionality of his extradition. And I think I've already indicated, if he could have availed himself of the protection, I accept that would have been determinative of proportionality. It would have been disproportionate to extradite him in circumstances where he had been denied the benefit of a bar which he ought to have had the benefit of. But if not, and the court properly concluded that he would not have been able to avail himself of the protection, then that would not be a factor to be taken into account in the Article 8 process.
And when you speak of availing himself of the provisions, you're meaning that he would have succeeded under those provisions.
Yes. Yeah. Yes. Yeah. And of course, I accept entirely that what the court did as part of this process and mechanism, which I'm making submissions on, was to proceed on a hypothetical basis. But the hypothetical basis was they were hypothesising as to what would have happened had the foreign bar provisions been in place. There was nothing about the facts that were before the court that would have been any different. There was nothing hypothetical about the facts. The sheriff was proceeding to consider the facts which were available before him, on the material before him, the evidence before him, but simply hypothesising that the foreign bar provisions would have been in place.
So you approach it purely on the basis of proportionality as opposed to in accordance with the law?
Well, again, my Lord, respect, I try to make clear the differentiation. In other words, what I say is that there was a mechanism available to the court to do it, and therefore that deals with the in accordance with the law part. That is inherent in the Extradition Act at the commencement of the proceedings, because one has Section 87, which requires the court to consider Article 8. And once, at the outset of the proceedings, it is plain that the foreign bar provisions are not in play when they should be, then it is inevitable that the court is going to have to require to address that through the medium of Section 87. So I seek...
Doesn't the court then also decide whether or not the present state of the law is in accordance with the law? Doesn't the court have to get past the in accordance with the law stage, first of all?
Well, the point that I make, my Lord, is essentially the one that I think my Lord Stephen highlighted when he drew, I think, Mr O'Neill's attention this morning to Lord Brodie's dictum in the court below. And it may be as well, I think, just to look to that, because that is essentially the point that I make, I think. It's to be found at page 291.
Sorry, page?
291 of the electronic file, my Lord.
Yes.
And really I focus on this, on the part of Lord Brodie's opinion, 5 lines from the foot of that paragraph, where he says, however, if before sending the case to the Scottish ministers in terms of Section 87.3, the Sheriff has effectively afforded the requested person the protections that Parliament intended that he should have, by considering whether, had the foreign bar provisions been in force, how this would have affected the appellant's position, it appears to me that any extradition which follows will be in accordance with the law. And that's effectively my point in a nutshell, because what the court did, being enjoined to consider the Article 8 rights under Section 87, and being required to look at this particular appellant's convention rights, this was the means, and if I may say the obvious means of doing it, to say, well, were his particular Article 8 rights interfered with, let us consider whether or not he would have been able to successfully invoke a foreign bar defence or not. And the distinction I make is, again, between the mechanism which the courts was available to the courts and which the courts chose to adopt, which is the in accordance with the law part, and the outcome of that assessment, which is the proportionality part. And the mechanism which was available to the courts and which the Sheriff adopted from the outset is, in my submission, a mechanism which was available under the extradition proceedings from the very outset of the proceedings. Section 87 is there, and the means of applying Section 87 in these particular circumstances, in my submission, was plain and obvious. And in fact, when one looks to the material that predates the Sheriff's hearing, in my submission, this was a process which was obviously available to the appellant, and it's a route that the appellant himself went down. And if I could just draw your Lordship's attention to 2 documents which I would highlight as supporting that proposition. The first is the devolution minute, which was lodged, of course, prior to the hearing before the Sheriff. And it starts at page 187, but if I could ask your Lordships to look at paragraph 2, Roman 17 and Roman 18, which is, I think, at 192. And at Romans 17, your Lordships will see what was said in the devolution minute is, according to the extradition request by the Government of the United States of America, the actions that the Minister is said to have carried out in committing the offence were carried out in Scotland, and it is submitted that therefore a substantial measure of his relevant activity was performed in the United Kingdom. Reference is made to the test in section 83A(2)A of the 2003 Act. So the appellant in the devolution minute in that paragraph is engaging with the first part of the hypothetical test. In other words, he's immediately engaging with the question of what would the effect of the foreign bar provisions have been had they been brought on me, had they been brought into force. And then in the following paragraph, Romans 18, it says, were 83A to 83D of the 2000 Act to be enforced in Scotland, there is a real prospect that the learned sheriff would decide that the extradition of the Minister would not be in the interests of justice in terms of section 83A. Now, if one then follows that through to what was submitted to the sheriff on behalf of the appellant, your Lordships will find, if I could ask them to look at paragraph 18 of the sheriff's decision, sheriff's judgment, which is to be found at page 220 of the electronic file. Paragraph 18 comes at the very foot of page 220. And this is the section in which the submissions for the requested person are being recorded by the sheriff. And what he records the submission as being is, the key question was the consequence of Lord Malcolm's decision in the judicial review. It was submitted that if foreign bar did apply, there was a real prospect of a favourable decision on foreign bar. It was accepted that that would be necessary to show that the requested person would have had such a real prospect of meeting the test in section 83A were it in force. And that is exactly the process which the sheriff then went through. It is exactly the process which the High Court on appeal followed in order to carry out that hypothetical process.
Yeah. That concession recorded at the end of paragraph 18, I think, is no longer being made by Mr. O'Neill.
No, and the only reason why I rely on it for today's purposes is that, given my submission is that from a legality in accordance with the law perspective, of course I recognise that there must be a process, there must be a mechanism in place which is sufficiently foreseeable, sufficiently accessible, is not arbitrary in terms of its outcome. And the simple point I make is that whatever is conceded or not conceded today, this is a process which the appellant, prior to and at the extradition before the hearing before the sheriff, obviously recognised was a mechanism which was open to him to follow. And in my submission, it was the correct mechanism. The sheriff correctly applied it, so did the High Court.
The way it's put, actually, the concession is rather more limited than the way you've expressed the test being in terms of whether a defence of foreign bar would have succeeded. The way it's put here is whether it would have had a real prospect of success.
I recognise that, my Lord, and I think that's probably consistent with the approach in various other areas of the law, and I don't think I would dispute that as being the proper approach. But nevertheless, that's the test upon which the sheriff dealt with it. The sheriff's finding, having applied the test hypothetically, was that I would need to check his wording exactly, but I think he was pretty definitive in his view that the appellant would not have been able to find the protection in the foreign bar provisions. It didn't turn, in other words, the test before the sheriff as it was applied, in the same way it was applied before the High Court, didn't turn on the question of whether it was a real prospect or otherwise. He simply couldn't succeed on the foreign bar provisions. And there is something highly curious in the generality here about the prospect of the appellant succeeding in a case like this, in circumstances where there has been a finding by the court at first instance, sustained, albeit on slightly different grounds, by the High Court, that this appellant would never have been able to succeed. He would never have been able to avail himself of the defence of foreign bar. So the simple point, I hope your Lordships understand why I take them to the devolution minute and to the submissions before the sheriff, was that the process, the mechanism which I submit was sufficient in order for the extradition proceedings to be in accordance with the law. It was an obvious mechanism. Section 87 is there. The obvious way of testing it was to say, according to this appellant's rights, was to consider whether he would have had the benefit of the provisions. And it was sufficiently obvious that it occurred to the appellant, it went in the devolution minute, and it was argued before the sheriff. So in my submission, it was a clear and obvious process by which the courts were able to determine whether the absence of the provisions impacted on the extradition. So to draw back, if I may, to the requirements of the term in accordance with the law, well, first, there is a basis in domestic law here for the appellant's extradition. In other words, in the 2003 Act, which of course remained in force, irrespective of the failure to commence the forum bar provisions. More specifically, through Section 87, there was a mechanism by which the courts below were not just able but obliged to assess the effect of that failure to commence the provisions on this appellant. And the key point in terms of legality rather than proportionality is that there was a means as part of the extradition process by which to take account of the effect of the non-commencement. And again, to address the point that my Lord Stephen raised this morning, the process was not arbitrary. The outcome could have gone either way, but the outcome was a question of proportionality. But the mechanism, in terms of Section 87 and the consideration of the non-commencement, was not arbitrary in terms of legality. The outcome, the sheriff had to decide one way or another, but that was simply a question of weighing the different factors which would have been at play under the forum bar provisions and deciding whether or not he would have had the benefit of them. That, in my respectful submission, is no more arbitrary than any other weighing process which a judge at first instance requires to undertake. So,
Sorry to come back to this point, but I'm still pondering on it. So on your submission, as I understand it, there is no point introducing the forum bar provisions. I mean, so can you tell me, so what is the difference then between your mechanism under the old law and the changes being made by the statutory reform?
Well, if I might draw back to the question of what the pre-existing law was prior to the forum bar provisions, because I think that might help in answering it. And I think this is addressed in our written case. Prior to the introduction of the forum bar provisions, in the generality, of course, the question of forum could be raised in the context of Article 8. But what was recognised, and I think probably was forcefully by Lord Phillips in the Norris case, was it would be only in the rarest of cases where otherwise the balance in terms of Article 8 was finely balanced, that the question of forum would tip the Article 8 question either way. And I can give your lordships the reference to that. I think it's paragraph 67 of Lord Phillips' judgment in the case of Norris. And one could see that in more extreme cases because there was, of course, the Scottish case of BH against the Lord Advocate, which came to this court, which I think my Lord Reid wrote the judgment on before they, I recall.
Yes, I was being appealed against.
I didn't like to say that, my Lord, but yes. Of course, in that case, the point was effectively it was two parents who were both to be extradited to the US. And in the context of that extradition, there were 6 children. And the point was that the question of whether they could be tried successfully in Scotland, if ever there was a case in which forum was going to tip the balance on Article 8, then that was such a case. But even in that case, this court decided that that was not sufficient to tip the balance in an Article 8 sense. So we have a situation in which the Article 8 assessment generally could take account of forum, but very, very difficult to succeed in forum.
But it's difficult to accept that the new law was effectively an anodyne formalisation of existing law, Because if it had been, why was the Lord Advocate so upset about it? I mean, the concern, well, the core concern, as I understand it, was that the new law enabled a court to review the Lord Advocate's decision as to whether to prosecute domestically, which hadn't previously, it was thought, what wasn't previously reviewable in Scotland, although analogous decisions had long been reviewable in England and Wales.
Your Lordship shouldn't understand me as saying that the foreign bar provisions were effectively to enact the existing law, because what I recognise is that what the foreign bar provisions did was to introduce a new freestanding defence. Yeah. And so, for example, and I recognise this, is that when forum was considered in the context of Article 8, what one would always have, the requested person would always face the argument that you can argue all you like about forum, but against that, in terms of the weighing in Article 8, one has a situation where there's the very, very strong public interest in effecting extradition, in complying with treaty obligations, in dealing with transnational crime and so on and so forth. So that's part of the reason why it would be so rare. But what the foreign bar provisions do is to make it a freestanding defence. There's no question of it coming into the balance in Article 8. If the test under Section 83A is met, then the defence is made out and there is a bar to extradition. Yeah. So what I'm not to be understood as saying is that somehow or other the foreign bar provisions, the enactment of them, the commencement of them, add nothing to what the previous law was. That, quite simply, that would be wrong. My point is that in this particular case, the mechanism, given that they hadn't been commenced... Sorry?
The mechanism was totally different, though, wasn't it? Because the foreign bar is a statutory bar. It's got nothing to do with proportionality at all. And what you're suggesting is the mechanism in this case is through proportionality.
Yes, I accept that, except to this extent, my Lord. Certainly the divisional court, and I'll need to remind myself of the case, has described the process that has to be undergone in terms of Section 83A as being very similar to the proportionality exercise in terms of Section 87. So there is a similarity, and certainly the divisional court against the Chief Justice in Love at paragraph 26 has made plain that the test on appeal under Section 83A, the foreign bar provisions, is exactly the same as the test for Article 8 proportionality issues. So there is a direct analogy between Section 83A on the one hand and a proportionality argument on the other hand. The fact of the matter is, the essential point I make is that with the foreign bar provisions not having been commenced in Scotland, but having been commenced in England, then stepping into the Article 8 world of Section 87, the particular way in which the court addressed that in this case, so as to determine this appellant's Article 8 rights, was to say, would he have had the benefit of these provisions? In other words, it's a different question from saying that the foreign bar doesn't add anything. It's saying it's unlawful that they're not part of the statute. So let us consider his Article 8
I feel
rights.
as if you're trying to have it with respect both ways. If in accordance with law means one's got to act in accordance with X, it's not much use then being told, well, actually there's a mechanism that gives you Y, which isn't quite X, but it's not far off. Because it's then not in accordance with law, i.e. law equals X.
Well, the way your Lordship enunciated is, I think, Mr O'Neill's argument. And if your Lordship, if he's right about that, then I accept that it's not in accordance with law. That would be the outcome
of that. Sort of saying, well, it's sort of in accordance with the law, or it's more or less in accordance with law. Isn't that what your submission is? Well, and that's good enough.
I don't think I'd accept that criticism of it, my Lord, because what I'm saying is, I mean, the way in which Lord Brodie said it in the Inner House, whilst I have adopted what he said as being an accurate position, earlier in his opinion he said, I think, something to the extent of what has been provided as something close to the protection that would have been afforded by the foreign bar provisions. And where I differ in that respect is the appellant here has had exactly the same protection. He has had equivalent protection because the sheriff has effectively, admittedly through a different mechanism, has said, would he have had the benefit of the foreign bar provisions? That question, in essence, is no different from if the foreign bar provisions has been in place. He has adopted exactly the same test, but simply under the 87 route. In circumstances where I accept that if the answer were favourable to the appellant, that would have been determinative of proportionality.
Isn't there a requirement for a certificate under the foreign bar?
There's no from the prosecutor.
Yes.
No, there's no requirement for a certificate, my lord.
But there's an ability to give a certificate.
There is an ability to give a certificate. That would be true.
So it's sort of the equivalent, but not quite.
Well, just to be clear, there are two provisions. I think there's under 83B. There's the ability to provide a certificate. And of course, if a certificate is provided, that is determinative that there should not be extradition and can only be reviewed on appeal on effectively a judicial review test. There is, in terms of Section 83A itself, one of the factors to be taken into account in the weighing process is whether the prosecutor has expressed a belief that it would not be appropriate to prosecute in the United Kingdom, and that would then be a factor to be taken into account in the weighing process. That is not something that could count against the interests of the appellant, because in the present circumstances, naturally, there was no expression of belief, and therefore what was taken away was simply a factor which would otherwise potentially have counted against the appellant. So in my submission, that sits with my submission that the appellant, through this means, had equivalent protection to the protection he would have otherwise had under the foreign bar provisions. There is, in other words, of the factors that did require to be taken into account on the approach that the Sheriff and the High Court took, there was nothing in there, there was no protection that the appellant would have had under the foreign bar provisions, but which he didn't get the benefit of.
And your argument also depends upon it being obvious that this is the route that the Sheriff would go down. That there would be no other route available to him, as it were. Well, obvious, as opposed to, because you also have to have a degree of certainty about the law, foreseeability.
I respectfully agree with that, my lord, of course. And the point I make is, of course, going back, well, Section 87 exists. A consideration of the appellant's convention rights is inevitable. As soon as one engages with that idea in the present circumstances, what other way is there to test this particular appellant's rights than to consider what the position would have been if the foreign bar provisions would be in place? And that's why, of course, I draw to your lordship's attention the terms of the devolution minute and the terms of the submissions that were made to the Sheriff. And indeed, I think even on Lord Malcolm's declarator, when Lord Malcolm, I think, finally made, and I can bring the page up in a moment, I think Lord Malcolm of course, he was not considering this question. He was considering the question of the unlawfulness of the failure to commence. But I think at the very end of his opinion, he made a comment to the effect of, in due course, this question will depend upon whether the foreign bar provisions would have applied to the... Respectfully, it seems to me that anyone looking at this, particularly in the shoes of the appellant's advisors, are bound to do what they did in the devolution minute. What else could one do but to say, I would have had the benefit of these? And it certainly would have been imperiling their position, or be a rather precarious position to say, I'm simply going to go before the Sheriff. I'm not going to argue that, but I'm just going to say that it's not in accordance with the law, but I'm not going to ask you, the Sheriff, to engage in the question of whether I would have had the benefit of these provisions. So I think the answer to that, my Lord Stephen's question, is yes, it would have to be obvious, and in my submission, it was obvious.
Can I just ask, procedurally, was the devolution minute dealt with in advance of the hearing, or was it all wrapped up? Do we find an order somewhere that disposes of it?
Required to check that. My understanding was it was simply wrapped up in the whole hearing, and Mr. McIntosh was there. He's nodding along with that. So it was simply rolled up as part of the whole hearing.
Thank you.
The only other matter just for me to raise in the context of this argument is just to draw to the Court's attention a particular aspect of the way in which the appellant's argument is formulated, because it seems to be that the appellant appears to acknowledge that he must bring himself within what he describes as the threshold requirement of the foreign bar provisions. And in doing so, at 6.2 of his written case, he relies upon the finding, in fact, by the sheriff that a substantial measure of the appellant's relevant activity was performed in the United Kingdom. And to that end, if I might just ask your Lordships, with apologies for bringing up the key provision, which your Lordships I'm sure have read, but if I might just remind your Lordships of the key provision of the forum bar provisions, which is section 83A. It's at 1030 of the electronic file. And it's really just to remind your Lordships of the framework of the provision, because subsection 1 provides that the extradition of a person to a category 2 territory is barred by reason of forum if the extradition would not be in the interest of justice. And then subsection 2 sets out the test. The extradition would not be in the interest of justice if the judge A decides that a substantial measure of D's relevant activity was performed in the United Kingdom, and B decides, having regard to the specified matters relating to the interests of justice, that the extradition should not take place. So both of those tests, what's described as the threshold test by the appellant under 2A, and the second part of it, the specified matters, are matters to be decided by a judge. And if I read the appellant's case correctly, he says that because there has been a finding by the sheriff in relation to Part 2A, the appellant is an individual who falls within the class of people whom Parliament intended would have the right to claim the protection of the forum bar provisions. Now, I simply make this observation that there seems to be a tension in the appellant's position, because on the one hand his position is that his extradition is simply not in accordance with the law, simply because the failure to commence the forum bar provisions was unlawful. But on the other hand, he appears to accept that to engage with the he has to engage with the hypothetical application of the forum bar provisions to some extent. He has to put one foot into the hypothetical world by engaging in the test under subsection 2A. And it's perhaps understandable why he does so, because if he didn't advance the argument in that way, then the result that would be that anyone who had been facing extradition in Scotland prior to the introduction of the forum bar provisions would have been able to rely upon the absence of the forum bar provisions, irrespective of whether there would have been any prospect at all of them claiming the benefit of them. So to take the example that Mr. O'Neill, well, the example that I think we made in our written case and Mr. O'Neill has seized upon, but if I might change it a little bit, because what it would have meant was that prior to the commencement of these provisions, that a US citizen, let's imagine a US citizen who's sitting in his house in Tennessee committing a cyber crime on a US securities exchange, he commits that crime and therefore all of the relevant activity, all of the loss and harm, all of it occurs in the US, but as soon as he's done that, he gets on a plane to go and visit his granny in Ayrshire and resides there, then even he, where there's no jurisdiction in Scotland to prosecute his crime, even he would have been able to claim the benefit of the forum bar provision. So it's perfectly understandable that, in my submission, would be a very odd outcome indeed if someone in that situation would have been able to claim the benefit of these provisions, or the lack of these provisions, rather.
Can I just clarify, in relation to that, when you mentioned earlier a dozen individuals who might be affected by this case, are they all people in respect of whom the proceedings in the Sheriff Court took place after Lord Malcolm had issued his declarator?
I would need to check that, my lord. I'm not sure. I mean, given the timescale, I'm going to be surprised if it were other than that, yes, given that the declarator was back in December 2018. Yes. But I can certainly check that.
Yes, we're not going all the way back to 2013.
No, I don't think so, my lord. I mean, of course, the logic of the appellant's position here is that, and again, if it weren't for this gateway acknowledgement, then every single extradition in Scotland from 2013 onwards would have been ultra-virus. Yeah. Of course, one might apply the cadre approach to that and say, well, those are all concluded and final, and therefore one can't reopen them, and one can see that. Yes. And really, this residual category of 12 are those where they're perhaps not quite finally closed. It's not all done and dusted yet. But The point I make is that it is understandable that the appellant here is prepared to put one foot into the hypothetical world, because otherwise it would be a very odd application or a very odd result of the foreign bar provisions. But logically, if once one takes one step into the hypothetical world, where is the logic to not putting both feet into it and assessing whether or not his rights were impacted upon in terms of 2B as well as 2A? It is difficult to see why a court would take one step in but not both steps in. And in my submission, that favours the approach which I submit as the correct one, which is that there was a mechanism for dealing with this, and jumping entirely into the hypothetical world was one which was perfectly legitimate and obvious. So for all of those reasons, unless I can be of any further assistance in this respect, for all of those reasons, my submission is that the appellant's extradition would be in accordance with the law. If I may deal briefly with oppression.
Now, you're eating into Mr. Webster's time, but I can leave you two to sort that out between you, I expect.
I don't content to concede my time at such, or at least a significant part of my time to.
I don't think I am. I think I'm eating into Mr. O'Neill's reply time, my lord.
Right, okay.
I think I had been allocated an hour and a half. Mr. O'Neill had 2 hours. I had an hour and a half. Mr. Webster had half an hour.
No, you were actually given an hour, but.
Oh, my apologies. I thought I had an hour and a half.
And then Mr. Webster had another hour, but. If you want to take longer and Mr. Webster gives up some of his time, then that's not a problem.
I think it's a mistake on the timing. Mr. Webster and I had agreed that we had agreed an hour and a half and half an hour.
Fine.
I'm pleased to hear that.
Yes.
In response to your lordship, my Lord Reid's query, all 12 decisions are decisions that were taken by the sheriff this year.
Oh. Thank you.
Next issue I want to deal with, but much more briefly, I think, is the question of whether there was oppression on the part of the Lord Advocate and whether that founds a separate basis for the appellant's contention that the extradition would not be in accordance with the law, because I think that's the way in which it's framed. I don't think Mr. O'Neill got that far this morning.
No, I don't think the argument's been put in quite that way. I mean, it's put in terms of being a breach of convention rights rather than in terms of a domestic plea of oppression. Mr. O'Neill will correct me if I'm wrong, but that's my understanding.
Right. In accordance with this court's devolution jurisprudence, it has to be in accordance with convention rights. Now, all I did was point out that the cases on abuse were done within the context of Article 6.
Yeah.
In which case, I don't think I need, subject to Ms. Irvine telling me otherwise, I don't think I need to address your lordships in that. Really then, the only last question, I think I can deal with it relatively briefly, so as not to allow Mr. Webster every opportunity he requires, is really the question of the proportionality of the appellant's extradition, because certainly on the appellant's written case, I'd understood the fallback position to be was that if it was in accordance with the law, somehow there was an error in the way in which the proportionality had been approached in terms of the balancing exercise, and that there was an error in the Lord Justice Clerk's reasoning.
I'm not sure if that's quite the point that Mr. O'Neill was making. As I understood it, the point being made was that the Lord Justice Clerk had erred in treating a proportionality analysis as addressing the point that was being made. That really, in accordance with law, is an issue quite separate from the question of proportionality. Well, and to that extent, the Lord Justice Clerk had adopted a mistaken approach. Is that right?
Yeah. In which case, my misreading of the case, and I do apologise, in which case I don't require to deal with that, because if there is no challenge to the particular outcome and the balancing of the factors, then there is no need for me to deal with that, my lords.
Well, we say that she took into account the irrelevant factors and therefore got the wrong, and those are the irrelevant factors. So, but it's all set out fully in our case, my lord, and my case is as clear as it can be, I think.
Well, it sounds as though you may want to say something about this, Mr. McBeatty.
better for safety, I think, Lord. The essential point of this, and when it comes to the weighing of the different factors under Section 83, and I appreciate, of course, I'm dealing with it on the hypothetical basis on which it proceeded, but nevertheless, the guidance as to how that should be approached has been set out by the Divisional Court in a series of cases: Love against Government of USA, tab 11, Scott against the Government of the USA, tab 41, Ejinieri, tab 42, and Atraskevich, tab 40. And the Lord Advocate accepts that those cases accurately set out the guidance which ought to be adopted by courts below in dealing with the balancing of the various factors in terms of the forum bar provisions. In the High Court, the evaluation of the various factors was to be found at paragraphs 32 to 38 of the opinion of the Lord Justice Clerk. That's to be found at electronic file 280 to 284, but I needn't ask your Lordships to turn it up just now. And it is right to recognise that what the High Court did was it did carry out a re-evaluation of those factors, because it concluded that two of the factors which the Sheriff had given weight to were factors which he ought not to have given weight to. And in particular, those were the factors under subsection 83A, subsection 3D and E. So that was whether evidence could be made available if the appellant were to be prosecuted in the UK, and whether any delay might result from proceeding in one jurisdiction over another. And contrary to the Sheriff's view, the High Court concluded that those should be left out of account, because there was really no basis for a proper comparison between the jurisdictions, because there was no suggestion that the appellant was ever going to be prosecuted in Scotland. And I don't think that's criticised at all. Once those were left out of account, the High Court was left with three factors to weigh in determining whether it would be in the interest of justice to order extradition. The first was the factor under 83A, subsection 3A, the place where most of the harm or the loss occurred, and it was concluded that that was the US. I don't think there's any issue taken with that as a matter of fact, particularly as it was in effect a fraud on the NASDAQ securities exchange based in San Francisco. Similarly, no issue is taken with 83A3B, the interests of any victims of the extradition offence, because in effect the Lord Justice Clerk identified that those victims are all again likely to be in the US. And that was left with the only factor weighing against extradition was the factor under G, the appellant's connections with the UK. And the Lord Justice Clerk accepted the Sheriff's approach that the appellant was of course thoroughly connected to the UK through citizenship, residency and no doubt other ties. But I simply observed that there was no particularly strong connections identified. So by way of contrast, for example, in the case of Love, what the Divisional Court relied upon was the particular weight or the particular strength in that requested person's connections, because he had family connection against the background of significant health problems, and if he was taken away from those connections, there was likely to be a very significant adverse effect on his health. There was nothing directly of that sort which was found. But the fact of the matter is that there is nothing, there's no issue taken with any of the factors here which the High Court has placed weight upon. And insofar as there might be a suggestion that your Lordship should reconsider the weighing process, in my submission, that's not a matter for this court. And that's the simple point to be made about it. For the sake of clarity, as I indicated earlier, the Chief Justice in Love against the USA at paragraph 26, and I'll just give your Lordships the page number, it's 1231. It's in that paragraph that he indicated it's the same test to apply to forum bar weighing as applies to Article 8 proportionality. In other words, whether or not it was wrong. And in the circumstances here, there's really nothing in the weighing process that would be for your Lordships to take issue with. It was properly carried out by the High Court, and it's not a matter that should be revisited by this court. I think the one point in the written case, and just for the sake of clarity, the one point the appellant in the written case takes issue with in this respect in relation to the Lord Justice Clerk's reasoning is at paragraph 37, and it does feature in the appellant's written case, so if I might just take your Lordships to it, because the relevant section is at page 283. Paragraph 37 of the Lord Justice Clerk. And at paragraph 37, it's in that paragraph that Lord Justice Clerk considers item G, in other words, the connections with the UK. And she assesses his connections, and then 6 lines from the foot of the paragraph towards the right-hand side is the section that the appellant takes issue with, in a sentence which commences, such a person, your lordships have that, such a person has a legitimate expectation that if he is to be prosecuted, he will be prosecuted in the United Kingdom. However, for reasons of good policy, the United Kingdom allows the extradition of its nationals who are resident in and otherwise connected with the United Kingdom, where their conduct has made them subject to the criminal jurisdiction of other territories. There is nothing in the Sheriff's approach to consideration G which amounts to an error. Now, I think Mr O'Neill ran out of time to deal with this, but I think the essential complaint about that part of the Lord Justice Clerk's opinion is that it was not legitimate for her to take into account the policy behind extradition in considering forum bar, because forum bar is a standalone defence, and therefore it doesn't encompass the kind of considerations that would come into play in a more traditional Article 8 balancing, where on one side of the Article 8 argument one would be looking to the reasons underlying treaty obligations. So I think that is the criticism, that in considering with connections with the UK, she somehow stepped into considering a factor that was not relevant. If your lordships were to consider there's any merit in that criticism of the Lord Justice Clerk's approach on that final section, in my submission, that makes no difference to the outcome of the balancing here, because what the Lord Justice Clerk had already assessed by that stage in her opinion was that there were 2 factors which she considered to be very strong factors weighing in favour of extradition. There was 1 factor, connections with the UK, which weighed against. And there's nothing that is said there which essentially interferes with the conclusion which she reached, the cogency of the conclusion. So in my submission, even if your lordships were to be found that she strayed beyond where she should have gone in that comment, then the conclusion is the same. The weighing process still should not be interfered with by your lordships. Unless I can assist further with anything else, my lords.
I don't think so at the moment, Mr Majesty. Thank you very much.
Simply
indeed.
move your lordships to refuse the appeal.
Thank you. Mr Webster.
Lords, if I can. My Lords, it will not have escaped your Lordships that the Executive is represented in 2 forms here today, in the form of the Lord Advocate and myself on behalf of the Advocate General, in terms on behalf of the Secretary of State. And much criticism has been made or at least directed towards the Secretary of State's position today. In many ways, that is the reason why I am here. Whether that criticism is ultimately relevant to the issue you have to determine, however, is another question. And in my suggestion, it's not. It may be part of the background to what is the resolution of an issue between the appellant and the Lord Advocate acting on behalf of the United States government. But to the extent that there has been criticism, if not opprobrium, directed to the Secretary of State, I wonder if I may be permitted, my Lords, just make a couple of observations on behalf of the Secretary of State. The first thing is to observe that the Secretary of State obviously accepts that the Secretary of State acted unlawfully. That is the declarator of the court. And there is no departure from that, and that is accepted. It is against the background where the Secretary of State's argument to the court was a belief on the part of the Secretary of State that the provisions within the 2013 Act which would permit commencement were habile to allow commencement in parts of the United Kingdom. The Secretary of State was told that's wrong. The Secretary of State accepts the consequences of that conclusion. But then it gives rise to the requirement to put right that which the Secretary of State has got wrong. And your Lordship has made reference to a constitutional convention that, insofar as the court would pronounce it a declarator of having acted unlawfully, the expectation is that the Secretary of State will respond to that.
Because in the absence of such a convention, the court will be asked and will be asked to make coercive orders, and there will be no good reason for withholding them.
Well, indeed, my Lord, indeed, my Lord. But the court does have this mechanism, which I submit isn't some constitutional solcism, of pronouncing a declarator that action is unlawful, and then leaving, as I characterise it in the case, a space for government to respond. For the consequence of the unlawful action may admit of a number of consequential steps to resolve.
Absolutely. But the problem here is almost 3 years past.
Well, let me deal with that then.
As you say, at the end of the day, this may turn out to be background if we're focusing on the act of the Lord Advocate. But I appreciate the Secretary of State's being criticised, and if you want to reply to that, then you're perfectly entitled to.
Well, on the point about the passage of time, whether your Lordship observes it's almost 3 years, and I entirely accept that a significant period of time has passed, whether all that would be in any way relevant in respect of a decision on the extradition hearing 6 months or 7 months thereby after the determination of the Lord Ordinary, whether it's 3 years as opposed to within the 6 months is perhaps neither here or there as well, and that perhaps factors into the degree of opprobrium to be attached to the conduct of the Secretary of State. But also, in my submission, it's not an unreasonable period of time that the Secretary of State has taken. It may appear long, but the reality of the situation is that a number of factors arise as a consequence of the decision of the Lord Ordinary. So the constitutional concerns of the Lord Advocate remained, and my learned friend Mr McBurty has referred to that in his opening submissions today. And the practical consequences then in constitutional terms arise for government as to what to do if one cannot, if it is to be the case that one has a constitutional bar to the creation of forum bar rights exclusively in Scotland. There's an immediate question for government as well. Do you impose them, notwithstanding the perceived constitutional? The
Parliament passed an act of as an act of Parliament. I mean, frankly, the more you address us along these lines, the more one would be inclined in future cases not to grant declarations, but instead to perhaps adjourn the case for a month for the appropriate order to be made, and if it hadn't been made at the end of a month, to grant an injunction.
Well, those are certainly issues which the court may wish to address, but I would hope, my lord, that the court would address that in light of a consideration of the issues which would then present government.
Well, it's perfectly simple. Parliament has passed an act of, has made an act of Parliament. All you have to do is sign a commencement order.
Well, indeed, my lord, but if the question for government then is to sign a commencement order, well, what would the practical consequences that would be? Would that create a constitutional difficulty in the light of?
It can't. The foremost constitutional rule is the sovereignty of Parliament.
Yes, but if Parliament had been asked to if the perception was that the statute permitted differential commencement throughout the UK, but that was perceived to be wrong, and it's been told to be wrong, then that then does give rise to a question then as to whether or not, had Parliament perceived that to be the case, would a different approach have been taken? Anyway, my lords, whether the propriety or otherwise of what happened, all I can do is explain to the court what has happened in the passage of time. And that is... I
can't understand what this constitutional problem was. I literally can't grasp it.
As I understand it, my lord, it was the Lord Advocate's concern that he would be required to state a position on whether or not he would prosecute.
That was initially. That was in 2013. I can't understand what the position was in 2018.
Well, still being maintained, my lord.
Yeah, but at the end of the day, so what? Parliament's passed an act of Parliament. I mean, and it's no answer to say, well, in light of a declaration, we might have gone back to Parliament to ask it to think again. Parliament has spoken. The court has told you there's an obligation to commence the legislation. End of story.
Well, with respect, my lord, the court has not told us to commence the legislation.
But it told you that your failure to commence it is unlawful.
Failure to commence it is unlawful, and that then gives rise to a question mark as to what the consequence of that is. How should the unlawfulness be remedied? And the unlawfulness can be remedied in one of two ways, either by giving commencement in Scotland, yes, or taking the decision to repeal the provisions for forum bar throughout the whole of the United Kingdom. If that was the only way in which the concerns set out by the Lord Advocate, if considered to be valid, could be properly protected. And that was given serious thought to, serious consideration was given to whether or not it would be appropriate, in light of the declarative which was pronounced, that it was unlawful to partially...
There's a third way, is you can commence it and then you can repeal it if you wanted to.
Well, yes, well, I accept that. I accept that. All I can say is what happened, which is that in the light of those alternatives...
Where's the evidence of all this?
Simply to give background, my Lord, to the criticism which has been made, and my Lord and the Chair has asked a legitimate question about going to the reasonable period of time when it would be expected for government to act.
I mean, I take the point that you can't. I mean, this is discussed in the RM case. I think that there are a variety of reasons why it may take time to commence provisions, and I appreciate you can't just make an order the following day, but even if you're having to consider whether there should be a change of policy and a proposal for repeal put before Parliament, it surely doesn't take as long as it took.
Well, in my submission, it took as long as it took in light of the issues which were live for consideration as a consequence of the declarative.
Well, I suspect next time Mr O'Neill finds himself in this position, he may be asking the court for a different remedy.
He may be, Lord, and perhaps then the Secretary of State will be in a position to advance to the court the reasons why the period which he is asking for it would not be acceptable in the circumstances. That's entirely right. But one should be careful not to perform an ex post facto criticism of what was done, where the court had created a space for government to resolve the matter, and however long it took.
Well, the court hadn't created a space. I mean, it hadn't been asked, for example, to adjourn the proceedings for a period of time so that the government could consider its position and form a view as to whether it was going to commence the provisions or put a bill before Parliament.
No, indeed not, my Lord. That is indeed the case. But equally, the court refrained from granting the specific implement which it could otherwise have done. So it did recognise that, perhaps in the lack of clarity in the expectation of when matters would be dealt with. Therein lies a difference of view as to the reasonable period of time in which matters should be resolved. All I can say is that in the time, a number of issues have been dealt with. The question of the Lord Advocate's ongoing concerns, the alternative ways which could be the issue could be dealt with. Views obviously have to be taken across government as to how the matter might be best dealt with. There is the constitutional consequences of potentially legislating contrary to Scottish Government and the devolved administration's desires. Advice has to be taken, and one has the issue of the changes in ministerial appointments.
I do hear what you say, but you really, the whole gist of this is that the government doesn't accept that Parliament has spoken and what it has said has to be implemented. Well,
if that is the impression I leave, then can I correct that, my Lord? It's not. It is a desire to say to the court that the Secretary of State government recognised the decision of the Lord Ordinary, did act on the decision of the Lord Ordinary, has indeed ultimately acted on the decision of the Lord Ordinary, and says to the court that the time which it took was the time which it took. And that may be a lengthy period of time, but in my submission there is nothing to suggest through the sheer passage of time alone that that amounts to an unreasonable period of time.
So at page 137, paragraph 28, the Lord Advocate in the first sentence makes a reference. I was wondering what your position about that is.
Well, yes, my learned friend has sought to water down the...
You don't think it's highly regrettable? Just so I understand it.
No, my Lord, no.
You don't think it's highly regrettable?
I wouldn't characterise it as highly regrettable. It is certainly unfortunate that it has taken as long as it has done. But
it only took as long as it did because the government wasn't prepared to accept that Parliament had expressed its will and its will ought to be implemented. The whole delay you're explaining is due to an unwillingness to accept that Parliament has spoken and a desire instead to ask it to have second thoughts. That's, I mean, that's turning the Constitution upside down.
Well, all I can do is give the explanation which I have to the court, my lord. And as I say, ultimately, what is the value of this, other than to respond to the criticism which has been made, so far as the issue which falls to be resolved today, which is the question of the actions of the Lord Advocate. Yes. And on that matter, I don't really have anything to add to the submissions which were made by my learned friend, Mr. McBearty, who in my submission articulates the point well, and that's why we divided our time as we did. The issue here is one between the Secretary of State and the appellant. And whilst we have an interest...
You say the Lord Advocate and the appellant.
Sorry, the Lord Advocate and the appellant. Whilst the Secretary of State clearly has an interest on the distinct issue of the principle of legality, in my submission, the approach which we set out in our case is the same as the approach which the Lord Advocate sets out in his case, which is to recognise that, so far as the test of in accordance with the law is concerned, the law includes Section 87, shortly put. And as much as Section 83A may not have been part of the law, Section 87 was. And therefore, when the issue of the inability to rely on the forum bar provisions comes to be considered in the convention assessment under Article 87, the fact that there are some individuals in the United Kingdom who get the benefit of the forum bar provisions, but others who do not, and do not get so because of what has been declared to be an unlawful failure to give them that rights, that is clearly a consideration relevant to the question of proportionality. But the assessment then is whether or not are there individuals in similar circumstances who are being treated differently. But when that assessment is performed under 87, what the Sheriff concludes is no, because you wouldn't have been able to avail yourself under Section 83A, even if you had the ability to avail yourself of the forum bar provisions. And so maybe to Lord Burroughs' question about if the law is X and then the law is Y, well actually X means A plus B, and in this case A plus B is Section 83A and Section 87. That is the law. It is the corpus of the law. And therefore there's nothing inappropriate in what was done by the Lord Advocate in seeking to present the extradition proceedings to the Sheriff. So I invite the Court in similar terms to refuse the appeal.
Thank you very much, Mr. Webster. Well, this is obviously a case of some significance and great interest. We will we'll endeavour to issue a judgment. These extradition proceedings have been going on a very long time, haven't they? So it's not a particularly urgent matter. Well, in that case, we'll issue a judgment in due course. Thank you.